we've studied about how in India we have this single integrated judicial system. So we have a three-tier judicial system. In this three-tier judicial system, at the national level, we have the Supreme Court. Below that, in every state, in the state level, we have the High Courts. And below that, we have the subordinate courts or the lower courts. In this video, we'll be talking about the second tier, that is the High Courts of India. So as we've seen that the High Courts are the highest judicial authority at the state level. So the High Courts are the apex courts in the states. Now let us go into a little bit of detail about the history of High Courts in India. So the first High Court in India was set up in 1862. The first High Court in India, the High Court of the Judicature at Fort William, which is now known as the High Court of Calcutta, was established in 1862. Around the same time, High Courts were set up in Bombay, Madras and Allahabad. So we have the Bombay High Court at Mumbai, the Madras High Court at Chennai and the Allahabad High Court at Allahabad. All these courts were built during the British Raj, and these together with the Calcutta High Court together make up the four oldest High Courts in India. At present in India we have 29 states and 7 union territories, but there are only 25 High Courts. Why is that so? Let us see. So initially the Constitution of India said that there will be a single High Court at every state level. But the 7th Amendment Act of 1956 changed this provision. So it said that one common High Court can be established for 2 or more states or union territories. For example, the Guwahati High Court has jurisdiction over Assam, Nagaland, Mizoram and Arunachal Pradesh. So as we can see that there does not have to be one High Court. In every state, 2 or more states can also have a single High Court. Now let us talk about the composition of the High Court. Who all are there in the High Court? So in the High Court, we have a Chief Justice of the High Court and other judges. So the High Court consists of the Chief Justice of High Court and other judges. Now the Chief Justice is the highest judicial authority in that High Court. So the Chief Justice is the head of the High Court and also happens to be the senior most judge in the High Court. He is responsible for taking care of the management in the High Court, and he also gives cases to the judges and sets up the constitutional benches. Now we know that the size of the states of India differ greatly, and the population, as we can see in this demographical map, also varies across the states. For example, let's look at Uttar Pradesh, which is marked in orange, and it shows that it has a much higher population than, let's say, Rajasthan, which has a similar size but a very different population. It has a much lower population than what Uttar Pradesh has. So as we can see, since there are a lot of variations in populations throughout the different states, the composition of the High Courts also vary across these states. Also, as we have seen that one High Court might be set up for 2 or more states or union territories, the High Courts in those areas need more judges than the other states. So that is why the number of judges in the High Court depend upon the population of the state or union territory, and it's not the same across all the High Courts of the country. Now, as we had said that the Chief Justice is the highest judicial authority at a High Court. Let us see how the Chief Justice is appointed. So the President appoints the Chief Justice of the High Court. But while we were talking about the judicial independence, we had seen that the President, who is advised by the Prime Minister and the Council of Ministers, can often bring political bias into this situation. So for that reason, the President's decision has to be in consultation with the Chief Justice of India and the Governor of the state. So the Chief Justice of India is the Chief Justice of the highest judicial court in the country, that is the Supreme Court. But the Chief Justice of India also has to consult with the two senior-most judges of the Supreme Court. Other than this, the President has to consult with the Governor of the state in which the High Court is situated. So the Governor of the state is the head of the federal state. The Governor in a state has the same position as the President has in the country. So the Governor is responsible for seeing that the Constitution is followed in the state. So that is why the Governor is also consulted by the President in the appointment of the Chief Justice of the High Court. Similar to the appointment of the Chief Justice of the High Court, the President appoints the other judges of the High Court, as we have seen in the appointment of the Chief Justice of the High Court. In appointing the judges, the President has to also consult with the Chief Justice of India and the Governor of the state. But along with these two, in the appointment of the judges of the High Court, the President also has to consult with the Chief Justice of the High Court. When we say the Chief Justice of the High Court, it is the High Court in which the judges are being appointed. Now let us see the qualifications for the High Court judges. So a High Court judge has to be an Indian citizen, because only an Indian citizen will be aware and familiar with the customs, traditions and the thought processes of the Indians. And the judge also has to be familiar with the legal system or the legal environment in the country. But simply being familiar with that is not enough, and he needs to have practical knowledge in this legal field, which only comes with being in the field for a long time, which is why we have a secondary requirement as well. So, the Constitution says that he must have been a judge in India for 10 years or more. So, the judge who gets appointed as the High Court judge should already have an experience of being a judge in any of the Indian courts for at least 10 years. Or he must have been an advocate of the High Court for at least 10 years. That is, he must have been a lawyer or an advocate in the State High Court for a time period of at least 10 years. This would make sure that the judge has a certain amount of experience before he is being given such a huge responsibility as a judge of the High Court. Now, after a judge has qualified for all of these requirements and is appointed as a High Court judge, before entering into his office, he has to take an oath. So, the judges of the High Court take an oath to show that they are committed to their position and their office. The judges of the High Court have to take an oath to bear true faith and allegiance to the Constitution, to carry out his responsibilities and provide justice without being partial, that is, having any fear or doing any favor, and he has to uphold the Constitution and the laws that are enshrined in the Constitution. Now, the oath of the Chief Justice and other judges of the High Court are administered by the Governor of the state or some person appointed by the Governor. A judge of the High Court has his retirement at 62 years, which means that a High Court judge can serve up to the age of 62. So, can you answer this question? What is the retirement age of a High Court judge? Is it 60 years, 62 years, 65 years or 67 years? Yes, a judge of the High Court retires at 62 years. There also has been a lot of discussion regarding increasing the age of retirement of the High Court judges and matching it with the retirement age of the Supreme Court judges of 65 years. It is said that that will be beneficial for the judicial system. Why is that so? It's because there are a lot of pending cases in the Indian courts. as of July 2021, there are 4.5 crore cases that are pending in the courts of India. So if we increase the retirement age of the High Court judges, then they will be able to stay for longer and therefore administer justice for a longer period of time. In 2019, the 46th Chief Justice of India, Ranjan Gogoi, requested the Prime Minister to raise the retirement age of the High Court judges from 62 to 65 years. So Ranjan Gogoi said that there are a lot of good Indian lawyers who are eligible to be High Court judges, but they opt out because the retirement age of the High Court judges is too early. And these lawyers, once they become High Court judges, will not be able to practice law. This is because of ensuring the judicial independence in the courts of India, as we've already studied in an earlier video. So that is why a lot of seats of judges in the High Court are vacant, and there is an immediate need to increase the number of judges so that it would not only reduce the number of pending cases in India, but also retain the best of the legal talents in India. There are two ways in which a judge might not continue till the age of 62 years. They are resignation and removal. So if a High Court judge writes his resignation and gives it to the President of India, then that is considered as his resignation from the office. Also, the High Court judge can be removed from his office by the President of the country. Now let us talk about the procedure for the removal of the judges. So the judge of the High Court can be removed from his office by an order of the President. So the President is the one who can remove a judge from his office. But to ensure judicial independence, there has been a provision made according to which a judge can be removed on the grounds of proved misbehavior or incapacity. Now, proved misbehavior or incapacity hasn't been properly defined in the Constitution, but if a judge commits a crime or does something that is against the provisions of the Constitution, he might be removed from his post. The judges of the Supreme Court and the High Courts are removed in the same process. Let us see what this process is. So, a motion for removal of the High Court judge has to be initiated in either House of Parliament. So, it can be initiated either in the Lok Sabha or in the Rajya Sabha. After the motion for removal has been initiated in either House of Parliament, an inquiry committee is set up. This inquiry committee consists of 3 members: a judge of the Supreme Court, the Chief Justice of any of the High Courts of India, and a distinguished jurist, that is a legal practitioner in India. This 3-member inquiry committee will look into the charges that have been brought up against the judge of the court. Now, this 3-member inquiry committee will submit its report to the house that had initiated the charges. So, if the Lok Sabha had initiated the motion for removal, then it will submit its report to the Lok Sabha, or if the Rajya Sabha has initiated the charges, then the report will be submitted to the Rajya Sabha. After the motion has been put forward in the Lok Sabha or Rajya Sabha, it has to be passed by that house. So, it has to be passed by a majority of the total membership of the house and at least 2/3 of the members sitting and voting. So, this is a special majority in which we have to take the majority of the total members of the house as well as 2/3 of the members that are present and voting in the house. Now, after the motion gets passed by the required majority in the Lok Sabha or the Rajya Sabha, it will go to the second house. And in this house, again, it has to be passed by a majority of the total membership of the house and at least 2/3 of the members present and voting. If the motion or the resolution is passed by both houses of the parliament, then the judge is removed by the president and the removal of the judge succeeds. In 2009, 58 members of parliament of the Rajya Sabha moved a motion in the Rajya Sabha against Calcutta High Court Judge Soumitra Sen. And this removal motion was passed by a very high majority in the Rajya Sabha. But after this was passed in the Rajya Sabha, Soumitra Sen resigned himself. He said that if the Rajya Sabha does not feel that he should be a judge anymore, he does not want to continue in his position. So before the resolution came to the Lok Sabha for consideration, he had already resigned. So the Lok Sabha did not try to pass the resolution anymore. So the judges of the High Court are very high judicial authorities in the country, for which they are given a handsome salary. The salaries of the judges of the High Court are charged on the Consolidated Fund of India, and they are non-votable expenditures, which means that the salaries of the judges cannot be discussed or voted upon in the parliament. The salaries of the High Court judges cannot be reduced during their term of office. Along with this, the only exception is during financial emergency. So, in financial emergency situation, when the financial stability of the country is at threat, it is only then that the salaries of the judges of the High Court can be reduced. Apart from the salaries of the judges are also given certain other benefits. For example, the judges of the High Court are entitled to the use of an official residence without the payment of rent. They are also given medical and travel allowances. There is also a provision for the pension of the judges of the High Court to ensure that they have a comfortable retired life. So in this video, we've talked about the High Court. The High Courts are the second rung of the three-tier system of the Indian judiciary. The High Courts are the apex courts at the state level, and they are responsible for administering justice at the state level. Don't forget to subscribe to our channel and hit the bell icon. You can also register for free at DeltaStep.com or download the DeltaStep app to get access to all our 5,000 plus amazing videos as per your school syllabus. Master each topic with our adaptive practice technology. Get million-plus questions with step-by-step solutions and unlimited mock tests. Get all your doubts resolved instantly. Learn via games and win amazing prizes like PlayStations and iPads. So at DeltaStep, learning is not just fun and easy, it is rewarding too. So register for free now.